right. I would like to welcome everybody on behalf of the Downtown Business Association to our weekly webinar. We have a great topic this week. It is estate planning, protecting your family and assets. My name is Chris Aitken. I am the chair of the DBA. I'm a principal of the law firm Aitken & Cohn. And I'm very happy to welcome this week Jennifer Elliott. Jennifer is an attorney for 17 years. She has practiced exclusively wills, trust, and sorry, I'm gonna do this as we go, there we go. Wills, trust, and probate law for the last 15 years. Jennifer owns San Clemente Estate Law, where she and her team of experienced paralegals create estate plans for a living, administer trusts after someone dies, and handles the probate process in court from start to finish when a person dies without a plan in place. Jennifer has two daughters in graduate school. Julianne is a nurse and is earning her master's in nursing. Jacqueline is earning her master's degree in Eastern medicine. In her free time, Jennifer likes to run and collect race bling. I like that, Jennifer. After 14 full marathons and countless half marathons, she can now be found running the hills in Rancho San Clemente or the beach trail. Again, I'm very proud and very happy to welcome Jennifer. Thank you for joining us.
Thank you, Chris, for having me. Thank you, Downtown San Clemente Business Association. So I want to start out by showing you where I'm located. I am downtown on Avenida Del Mar at the corner of Ola Vista. This is the exterior of my office. It's decorated for Christmas in this picture. If you know where H.H. Cotton's restaurant is, then I am right upstairs. So
that's a great place, Jennifer. I appreciate the plug.
That is a great place. And when everything reopens, we are going to be back to normal and celebrating at H.H. Cotton's. So this gives you a reference point, lets you know where I'm located. Now, I've heard some people say, I'm nervous to come to your office. I don't want to be at a lawyer's office. And you might hear this as well, Chris. I guess we're scary people. I don't know. But if you flip to the next slide, you'll see the office is warm and welcoming. It's not a scary place. I have a friendly staff. And these are a couple of my paralegals, Kathy and Gabe. So it is warm and inviting, nothing to be nervous about to come to a law office and get your affairs in order. I want to show you something I'm handling right now. So if you flip to the next slide, in light of COVID-19, I've heard some clients say, I'm nervous about what procedures you have in place. I want to sign my estate planning documents, but I'm nervous about going outside and exposing myself and increasing the risk of infection. So this is what my office is doing. We are setting up safe signing appointments during the pandemic. So this is my paralegal, Gabe. He is also our notary public. We set out a table outside so we have the free flow of air. We've got masks, gloves, Clorox wipes. And what we do is we sign, we go over the estate plan with clients via Zoom call or by phone. So we have completely gone through the documents with the client at the time, before the time that they come in to sign. So we make this appointment 10 to 15 minutes max. They're just coming, signing their documents, and then we will provide them the binder with all their estate planning documents later. So I've heard that some offices have told their clients, we're closed. We don't know how to handle this pandemic situation, and we'll be back when it's over. But at San Clemente Estate Law, we are still helping new clients and getting our existing clients signed documents so they have peace of mind. So with our next slide, I want to talk about how to get prepared for COVID-19. Now, in some of your emergency kits, I'm sure you've seen over the past couple of months, those emergency kits include toilet paper and canned goods and food, and they should. But there is an important item in your emergency kit, and that is getting your estate plan in place. So regardless of whether you're preparing for COVID-19 or a recurring virus that they're talking about might hit us later in the year, or just future for your life, because it's not if we're going to die. It's a when. And so these documents can get you in good shape to protect yourself and your family if you become ill now or later on at the end of your life. So let's go to the next slide. These are the documents that I'm talking about that you need. Every adult needs these documents: a power of attorney for finances, the Advanced Healthcare Directive, and a will. You also need a trust. Now, not everyone needs a trust, so we're going to go through that. So let's talk about each of these in detail. This first document, this is a durable power of attorney for financial affairs. Who's going to handle things for you if you become ill? Who's going to make sure that you have everything you need if you're incapacitated? So for example, if you have chosen a person that you want to handle things for you, how do you know that they have access to your funds to be able to provide the care that you need while you're recovering? And so that document is a durable power of attorney for financial affairs. That person's going to have the power to pay your bills and hire the help you might need until you're well.
And there's a question, what if the power of attorney is 20 years old? Is it still valid, Jennifer?
Well, that's a good question. Some banks interpret old documents as being stale, so it depends on your bank. I've heard some banks say a 10-year-old document is stale and should be updated. So it is a good idea if your documents are dated more than 10 years old, just do a new power of attorney, because you won't learn that the bank isn't going to accept your document until it's too late, until you're incapacitated, too late to sign a new one.
Perfect. Thank you.
So another document I want to talk about, the legal document you must have if you become sick, and that is the Advanced Healthcare Directive. So this is a document where you nominate an agent. This is a person that you trust to make medical decisions for you if you can't communicate with doctors or nurses. Now, you've laid out all of these decisions ahead of time while you're well. So, now is the time to set up these decisions if you haven't already. And then when you're not able to communicate with doctors or nurses, it could be because of you're ill with COVID-19. It could be because you have had a stroke. It could be years from now and you get a diagnosis of dementia. Then you've already set forth your wishes and you've nominated a person who can carry them out. And so this document covers things like, do you want to be buried or cremated? What kind of end-of-life decisions do you want? So all of those things are covered in this Advanced Healthcare Directive.
Whichever, then who needs an Advanced Healthcare Directive? How does that work?
Everyone over the age of 18 needs a healthcare directive. I know that seems silly that a college kid should need these documents, but they need both a healthcare directive and durable power of attorney for finances that we just went over. If you send a child off to college and you need to call their tuition financial assistance office, for example, they are not going to talk to mom or dad if your child's over the age of 18. So that durable power of attorney for finances is going to help you manage things for your young adult as well. So anyone over 18 needs both the durable power of attorney for finances and the Advanced Healthcare Directive. Now let's go to the next slide, and I want to show you how families can protect themselves if you pass away and when you pass away. So far we've been talking about the powers of attorney. Those documents are effective only during your lifetime. They expire when you die. So when you die, you need to have some other documents that come into play, and that is your will and your trust. So with that will and trust, this is planning and giving power to a trustee for the event when you pass away. Let's see. Any questions coming in? And please feel free to interrupt me.
Oh, yeah. No, I appreciate that. But yeah, Jeff, there is one question that's come in. One is, how does someone know if they need an estate plan?
So I hear this often. People will say, I don't have a lot of money. I don't need an estate plan, or I just have my house. And I cover this in the next slide. If you have a will, if you have a home and if you have a bank account, then you have an estate, and that means that you need an estate plan. So a house is something that doesn't have a beneficiary card on it. You can't just state who you want to get your house when you pass away. There are only two ways to transfer title to a house when someone passes, and that is with a court order, and that's a judge, that's a probate process, or through a trust where you've given a person that you designate as your trustee the power to sell your house and wrap up your affairs after you die.
What happens though when a person dies without a will or trust? How does that work?
Well, now you get into probate. So I think that's coming up at this next slide. Yeah, so if you don't have an estate plan, state of California has that all worked out for you. They have a plan for you if you don't have one. And the bad news is that might not be what you want to have happen. So if you haven't nominated a person to handle your finances during your incapacity, then a family member needs to step in, and they go to court, they request a conservatorship over your affairs. So now the court is involved, and this is completely unnecessary if you have estate plans in place that include durable powers of attorney. Then when you pass away, the court, without a will or a trust, the court decides who gets your assets, who is in charge of distributing those assets. So it is a good idea to put your own plan in place so the state doesn't use a probate code to distribute your assets.
And how long is the probate process, Jennifer?
The probate process is in Orange County right now. It runs about 18 months. Unfortunately, with COVID-19, as you know, the courts are still closed. And so that is going to add at least another 3 months, maybe longer. All of my hearings right now, and I'm sure yours too, they're just in limbo.
Yeah.
Some of them haven't even been rescheduled yet because the courts are still uncertain about what's happening. So it's a long process. It is unnecessary to have this. Your trustee should be able to handle everything within just a couple of months if you have a trust. So that probate process is avoidable. If you turn to the next slide, Chris, then I talk about a couple of other reasons why you want to avoid probate. The next, other than time, the other drawback is privacy. Your affairs are completely public if you don't have a trust. So I think that the artist Prince is a good example of this. He died without a will or a trust, and we know all of Prince's business. We know about all of his assets. When Prince died, wow, it's been 4 years now since he died. He had about a $300 million estate. And so far, I've heard that the attorney fees are in the area of about $45 million.
Wow.
There was also a 40% estate tax that had to get paid to the IRS. And he lived in Minnesota, so there was a 16% state estate tax. So had he had a will or a trust, even with a will, a probate's necessary. Had he had a trust, he could have avoided much of those taxes, and definitely he could have kept his estate completely private. And then the last drawback, the biggest drawback, is the cost of probate, which is avoidable. Let's look at the next slide because this covers how much probate costs. People say, I know I want to avoid probate, but I'm not really sure why. And this outlines that. So say a basic estate in Orange County is $1 million. Now you might say, I don't have $1 million, Jennifer, but if you've got a house that's worth $700,000 or $800,000, even if you have a mortgage on it, the court looks at fair market value. Now I've lost this slide, but that's okay, it'll come back. There we go. So the court looks at fair market value on the house. So even if you've got an $800,000 house and that's a $400,000 mortgage, the court still calls that $800,000. So say then you've got some personal property like a vehicle, furniture, furnishings, you've got some money in the bank. So you can see how it's pretty easy to get up to a $1 million estate. On a $1 million estate, if you were to set up an estate plan, now the cost, it depends on the attorney you hire, it depends on how complex your estate plan is, what beneficiaries we're trying to protect, whether they're young kids or step family situations. So I'd say the range for an estate plan is between $3,000 and $6,000. That's your will, trust, powers of attorney, everything. But if you have to go to probate, the cost just in attorney fees is $23,000. Then there are administrator fees of an additional $23,000. And then there are court costs. Those are the court filing fees. So you are up to $50,000 that never is given to your family. And so that can be completely saved if you're over in the trust column. You don't have to deal with the time for probate and the expense for probate. Let's look at the next slide, Chris, because some people will say, well, I don't have $1 million estate. It truly is, more modest than that. I have a condo and maybe the total value of my estate is $500,000. Well, cost of probate is $26,000 plus the court costs at the bottom of $4,000. So that's still $30,000 that your loved ones don't see. And then you can follow the chart based on the value of your own estate. And gosh, $20 million, who wouldn't want to save $326,000? So when people say, I don't have an estate, I really urge them to talk to an attorney and avoid unnecessary taxes, estate fees, court costs.
Jennifer, if there is a question, if someone watching already has a trust already in place, and like first, how often should they update it? What would be your thoughts on that?
I tell my clients they should come back and see me once every 3 years, or when something changes in their lifetime. I outline a few of those issues. If we go to the next slide, then this outlines some other instances in your life when you should come back and see your estate planning attorney sooner. If you've had a marriage, you probably want to provide for your new spouse. Or you might want to just make sure that that your new spouse is acknowledged and state that you don't want to make any changes to your current plan that protects your kids from a former marriage. If you become widowed, then you want to update things. If you've had a child, you certainly want to protect a new child. And if you don't name that child in your estate plan, that's going to require them to go to court. That's happening right now in the Kobe Bryant estate. He died with a trust, but only his 2 eldest children were included. The 2 youngest had not been included. So his idea of keeping his family out of court did not occur. His widow has to go to court and get those 2 minor kids included. So she ends up in court where the intent was that we avoid court, but it wasn't updated. The next thing is if you bought a new home, all real estate should be in trust. So buying a new house is your trigger to go back and see your estate attorney and make sure you protect that and get it titled in your trust name. Maybe the person you chose as your trustee is no longer your best choice. Maybe you are estranged. Maybe that person has taken up gambling. This happened once in my practice where the trustee just did not make good decisions with his own finances, and therefore the client said, I don't want this person handling my finances. So we had to do a redo of the documents and choose someone that was more financially responsible. Changes in the tax code and changes in the law. Even if you say none of these things have happened in my life, Jennifer, you've got to look at the law and the tax code. As you see, the tax code and IRS rules, they are changing daily right now. So it's a challenge to keep up with this. So unless you are reading up on the daily laws or taxes, go see your CPA go see your estate attorney and make sure that you're current. Finally, changes in the stock market. Some of my clients have told me recently, I've lost 20% in my stock portfolios because of the pandemic, and they're worried. Of course, the market is going to fluctuate, and hopefully it comes back. But if you have a trust where a certain amount was designated, I had this last week, $200,000 was given to a specific charity. And with that 20% drop in her stock portfolio, she couldn't afford that anymore. So those are some reasons why you need to review your estate plan. Make sure it still works for your current situation.
Here's one question. What can our attendees, our viewers here, do to protect themselves?
Okay, so there are some things that you can do today, and I have a slide on this. I think it is the next one.
Okay.
Yes, so I want to make sure that people talk to their spouses and talk to your kids. Now, if your kids are age appropriate, we've both got older children, and so you have to kind of vary this. I think you have some little ones, don't you, Chris?
I do. My youngest is 12, oldest is 20. So using my situation, or however you want to do it, Jennifer, what's your advice?
Well, it's probably okay to talk to the 20-year-old, depending on their level of financial maturity and emotional maturity. But the 12-year-old, we could hold off depending on their level of maturity. I have a 24-year-old, a 25-year-old. I also have a 35-year-old stepdaughter. So I have talked to them about my estate plan. That way they know what assets I have. They know what's going to happen when I die. They know who's in charge. So they know to go see the trustee and who's going to make sure they have everything they need until they get distributions. The other thing that you can do is make sure that your estate plan is updated. Make sure that you've got those powers of attorney in place. But talking with your family is going to go a long way to prevent litigation. That is of course how we make money, and you can avoid the court process. That's what I do at San Clemente Estate Law. Is I draft documents that keep families out of court. So even though I do have to go to court, I do handle that other part of the matter. I do probates when people die without having their plans in place. But because I've done that so many times and I've been before court, I know what plans work and what plans don't. So it's so helpful for families to keep them intact when a loved one is gone, is to talk to each other so they can maintain those relationships. There's no surprises in the estate plan, and siblings can still have good relationships.
Yeah. I've heard so many stories, Jennifer, friends of ours, et cetera, when they don't have the right plan in place. It does create a unintentional mess for the family. And I have to agree with you that obviously we are lawyers, but litigation is not necessarily where you want to be, right?
Right.
It is what it is. I guess as relates to one question is,
Oh, you froze for a second there, Chris. Oh, you're still frozen for me, Chris. Okay. I'm not sure if I'm frozen, but I'm in a technology, challenges in technology, but we're going to go ahead and succeed anyway. So if the viewers can still see me, oh, you're back, you're back. Chris, can you see me or hear me? There we go.
I'm sorry.
That's okay.
You're there. Okay.
Zoom is certainly a challenge lately.
By the way, this is just to be clear, this is my technical glitches. I apologize to the audience and to Jennifer here.
No, that's okay. I've been using Zoom with my clients, and before about 6 weeks ago, I didn't know what Zoom was. So we are all learning technology together.
Yes. So anyway, so tell me. So again, kind of refresh here, if you could talk to us a little bit about LegalZoom do-it-yourself kits and what your thoughts are on that with your slide here. Again, my apologies.
Oh, no, no problem. So I want to tell you about a client that I had. This was a widow who came in to see me, and her husband passed away of pancreatic cancer. Her husband was a lawyer before he passed away, and he knew he was ill. He knew that pancreatic cancer was not going to give him much time, and he set out to do his own estate plan. Now, he thought, as a lawyer, I can do this myself, and he decided to go with LegalZoom. He drafted his own documents on LegalZoom, thinking, I've been to law school, I have this kind of training, I can do this and save some money. So he drafts a document. He chooses a trust that was not appropriate for their family situation or for their assets. He picked an AB trust, and part of an AB trust becomes irrevocable on his death. Now, this was a couple that had been married a long time. They had 3 children in common. There was no need for them to have an AB trust like we still use sometimes in step-family situations or where there are a lot of assets. But this wasn't necessary. But because he drafted that AB trust and it didn't become necessary to review it by an attorney until after he died, the wife was stuck. So she wanted to sell the house, she wanted to scale down, she wanted to move around some assets, and her hands were tied as to 1/2 of the assets that became irrevocable. So that was a problem. And had he had an estate planning attorney draft the documents, then they wouldn't have been put into that type of a trust. So what I had to do was go to court and undo that irrevocable trust that allowed the widow to take care of things. Completely unnecessary. We all know that was not his intent to put his widow into the courthouse. He was trying to make things simple for her and for their 3 kids. But what I'm saying is, even if you think you know how to do it, go see an estate attorney. I review LegalZoom documents all the time, and thankfully people bring them into me when they're still living, and we have an opportunity to correct them. Once in 17 years, I have seen a do-it-yourself plan that would have worked. So the problem with do-it-yourself plans is it's like you've got to test drive a car. And if you haven't test driven this car to make sure that this is going to work at the time that you die, that car could break down for your family when they need it most. So I've test driven estate plans that I've written for 17 years. I go to court, I see what works and what doesn't, and I can draft a plan that avoids a probate court. So the problem is, if you do it yourself and there are problems with it, you don't find out until it's too late. So I would caution against doing that. A couple of times people have said, I'm going to do it myself anyway. And I say, here's my business card, put it on your refrigerator. Your kids might need me one day. So I'd say if you're an estate planning attorney, you can probably get by with using LegalZoom. But if not, please go see your own lawyer who does this. Incidentally, most of our clients are attorneys, CPAs, financial advisors, people who could have the knowledge to draft these things themselves. But they know how important it is to have a document that works when you pass away. So they know, go see a estate attorney. I didn't do my own divorce. I went to a divorce attorney, and my divorce attorney came to me to do her estate plan. So even the professionals know, get it done by the right person.
I agree, Jennifer. I mean, as you know, I'm a personal injury attorney. There's no way I'm doing my own estate documents. I mean, that's a specialized field that an estate attorney like yourself should get involved. I totally agree.
Exactly. And if I were ever injured, I would come to you. I would never attempt to settle my own personal injury suit.
But there's an old saying about that, Jennifer. I don't know. It's something about fool for a client or something of that nature. No, you specialize, and when you specialize, you go to the specialists for the stuff that they do. Hey, I do want to, this is not a question, but a shout out from our attendees. It says, I just want you to hear this. We did our estate and trust with Jennifer and her team. They are fantastic. Jennifer is super patient, non-judgmental, and really listens to your needs. So it's not a question, but a shout out to you. So I wanted to share that with you from one of our attendees.
Ah, thank you. I appreciate that. I've heard that a couple of times over the years. A client came into me and said, I'm not going back to my old attorney that first drafted this trust because he decided how I was going to distribute my assets. That's crazy.
Oh, okay.
Yeah.
All right. I guess that's one way to go.
That's one way to go. But I listen to my clients. If they want to disinherit a kid, I let them. And if they have specific ideas for what charities they're passionate about, then I listen to them. I never put them into a plan that I want. And so I want to tell you a couple things about my practice. I have 17 years experience. San Clemente Estate Law is active in the community. We're members of the San Clemente Chamber of Commerce, members of the San Clemente Downtown Business Association. We are at all of the events. Gosh, I can't wait till our events come back to the downtown area. They will come back. The pandemic is going to end. We're going to get back to normal life.
Well, we'll get them back, Jennifer.
We will.
We're doing our best.
But we've drafted thousands of estate plans. And so there are some attorneys that are throwing their hat in the ring because there are some areas of law that are not very active right now. So some people are saying, oh, sure, I'll do an estate plan. Well, again, you want to make sure you have someone experienced in this area. So we do have attorneys and financial advisors, CPA clients. And another issue, you hear this too, Chris, people complain about attorneys and they say, we don't return their calls or we don't get back to their emails. And client communication is really something that is important. And I think the State Bar says it's the #1 complaint that people have with lawyers. And so I'm sure your firm does this too, but we have a policy that we always get back to clients in the next business day, whether it's a phone call or email. So you will get a response.
Well, absolutely. It's important. And people need to be heard. You got to get back to them. And I'm sure, Jennifer, you take the same position. No, there aren't any stupid questions, especially when it comes to these kind of technical issues that we deal with. Wouldn't you say?
Yes, yes.
Okay, well, I appreciate is there any other, I guess, what I want to ask you, is there any other kind of final thoughts you have? Anything else you'd like to talk about, Jennifer? Thoughts for San Clemente? Anything else you want to say?
I do. Thanks, Chris. Like I said before, San Clemente's coming back. In that picture that you saw at the beginning of the slide, I have in my front office window the SC Stay Strong poster. And yes, so that is, we're rooting for the city. We're going to be back. And I want to remind people that even as we speak, the restrictions because of COVID-19 are loosening. And that is a great thing. You still need to get this estate plan in place because even though the pandemic is going to end, we all need to plan for our eventual passing. We still need to protect our family. We still need to protect our assets. So it is a good thing to put on your to-do list. When people leave my office, they say, I can't believe I haven't done that yet. That gives me so much peace of mind to know that that's in place.
I agree. Well, Jennifer, we really appreciate your seminar today. It gives us a lot to think about. Thank you very much for joining us. We really appreciate it.
Thank you, Chris. Stay healthy.
All right. Take care. Thank you.
You too. Bye-bye.
Bye-bye.